Hello, everyone, and welcome back to the Regent Law Podcast. On today's episode, we'll hear from Judge Kyle Duncan of the United States Court of Appeals for the Fifth Circuit. He's interviewed by Brian Stokey, third-year law student, as part of our series on the administrative state. We hope you enjoy. Thanks.
Next, we'll hear from Judge Kyle Duncan of the Fifth Circuit Court of Appeals. Thanks for being with us today, Your Honor.
Thanks for having me.
It's a privilege to have you. We want to start off by asking you, how did you get to where you're at? Obviously, you weren't a Fifth Circuit judge to begin with, and we would, if you want to elaborate on how you got to that position, I think that would help our listeners give some context.
Certainly, and I'm very grateful that you invited me to be on this podcast. I am never expected to be on the Fifth Circuit, never expected to be a federal judge. And in many ways, I'm the last person who anyone would have expected to be a federal judge. And the reason I say that is because for a large part of my legal career, I was involved in highly public litigation on a variety of topics. Some may describe them as controversial. They were often in the public eye. And when lawyers are involved in such cases, often they don't get appointed to federal courts because it becomes more difficult to get them through the Senate, frankly. So to answer your your basic question, which is how did I end up here? I mean, the basic answer is the grace of God. But to sort of chart out the path, which was by no means a straight path, I graduated from Louisiana State University Law Center. I was born and raised in Baton Rouge, Louisiana. I did not intend to go to law school and applied because I couldn't think of anything else to do with my life, which is not a good reason to go to law school. But when I got to law school at LSU, which is an interesting law school, it's a mixed jurisdiction, meaning you learn both civilian and common law legal systems, because of the Louisiana's heritage coming from the French and the Spanish law. For example, you take property as an elective in Louisiana. The typical property class that y'all study here, you take that as an elective, and you take the civil law property. So it's an interesting mix of cultures. I intended to practice law in a firm in Baton Rouge and just live out my life there and just do that. I didn't come from a family with many lawyers, actually no lawyers now that I think of it. So I didn't really know what the career of a lawyer needed to be. I did have one professor who was very helpful to me named Jay Bybee, who's now a judge on the Ninth Circuit Court of Appeals. And he encouraged me to clerk. I didn't really know what clerking was. I didn't know why one should consider doing that. And yet he encouraged me to do it and helped me get my resume in front of several Fifth Circuit judges. And I was fortunate enough to get a job clerking for Judge John Dewey. He was a wonderful judge. His chambers were in Lafayette, Louisiana. I loved it. I loved the work of the court. I loved being a clerk. My mother told me this story just last month. She always tells this story, which is when I was clerking for the Fifth Circuit, I said, I could do this as a career. This is great. Because you get to do interesting work. You get to advise a judge on here's how I think the case should come out. So you're doing something important for the law, for society. The cases are interesting. I could do this as a career. And there are people who do that as a career. It's a very good career. Some judges have career law clerks. But of course, I didn't get a job as a career law clerk. I didn't even apply for one. I went to work in private practice. But to sort of summarize this, I ended up doing a good bit of work for government. I worked for the Texas Attorney General's office back when they were starting the Solicitor General's office, which is now grown. This was 1998, 1999. It's grown to a large office. It does a lot of important work in my court and the United States Supreme Court. I did that. In the course of my career, I also was able to start, in a sense, the office of Solicitor General in Louisiana. At the time, I was called the appellate chief of the Louisiana Department of Justice, and since then, it's now the Solicitor General's office, which, although it's smaller than the office in Texas, still does good and important work. And I've sent a couple of clerks to that office, and I certainly hope that it continues to thrive. Mississippi has done the same thing in our circuit, so started a Solicitor General's office. And incidentally, that's the office that argued the Dobbs case that resulted in Roe versus Wade being overturned. So a lot of my career was devoted to that, to doing government work, defending the government. And that was interesting to me because it allowed you to get into constitutional law issues. And I found those very engaging. In the midst of all that, I got an LLM from Columbia, and I taught constitutional law and some other related classes at the University of Mississippi. So I had the academic side to it. My specialty there was I focused on the First Amendment, the free exercise and religion clauses. And in the midst of all that, I had this interesting opportunity to move to Washington, D.C. to be general counsel of the Beckett Fund. The Beckett Fund's a nonprofit law firm, very well regarded, does wonderful work, does religious liberty litigation of all different types. And I went there. I was very fortunate to be hired as their general counsel. And this was around the time that there was widespread litigation against the so-called contraceptive mandate in the Affordable Care Act. And Beckett led a number of important lawsuits against that on the grounds that it violated the First Amendment, on the grounds that it violated the Religious Freedom Restoration Act. And the court, our largest case there was on behalf of Hobby Lobby and the Green family, which we were fortunate to get to the Supreme Court and won that decision. We were very pleased, and more importantly, our client was very pleased.
Amen.
At that, and they're wonderful people, and I'm still see them occasionally, still hear from them occasionally. They're great people. So after that experience, I've started my own law firm in D.C. to try to focus on that kind of sort of public interest litigation. Ended up representing some former clients from government. My law firm is still doing well. My name's not on it anymore, but it's still doing well, and it's growing and does lots of interesting work. And so in the midst of all that, you do this kind of litigation, you get to know people in this space. And it just so happened, this was not planned, that when President Trump became president in 2017, some of the people advising him on judges looked at me as a possible judge for the Fifth Circuit. And that was somewhat surprising to me, again, because of what I said earlier. I mean, these cases, I thought Hobby Lobby was an important case. Many people thought it was a bad case. Many people thought it was a controversial case. And some of my other cases, I defended Louisiana's man-woman marriage laws for the state as outside counsel. And I was privileged to do that. No matter what you think of that issue, and obviously many people in our society disagree with Louisiana on that issue, those issues get litigated. That's for better or worse. Many of these important societal issues end up in federal court. And it's a fundamental tenet of our judicial system that both sides need good representation. So I was privileged and honored, and still am grateful to have represented clients like that in federal court. It didn't win me much popularity, but popularity and acclaim are not always good reasons to do things. And so when I was nominated, and I credit the Trump administration for nominating somebody like me. I give them great credit for that, and I'm grateful for it, because it's a risk to nominate someone with that kind of record. Even though it ought to be obvious that, say, a lawyer who represents controversial clients ought not to be controversial on that ground. As a matter of fact, that's what lawyers are supposed to do, see? And not that I'm comparing myself to John Adams, but John Adams did that. He represented British soldiers who fired on civilians during the British massacre, and got some of them acquitted. Matter of fact, hurt his legal practice, but he did that. And so lawyers on both sides of sort of the political divide do that sort of thing, and they ought to. That's why we have a legal system. I was privileged to do that. By the grace of God and dumb luck, I ended up being nominated to the Fifth Circuit, and I'm will always be sort of amused that happened. I'm grateful to be on the court. I love the Fifth Circuit. I practiced. I argued cases in front of the Fifth Circuit. I clerked for the Fifth Circuit. Obviously, the jurisdiction of the Fifth Circuit is Louisiana, Texas, and Mississippi, and I grew up in Louisiana. So I'm very, very grateful to be on the court. It's a great court, full of great, intelligent, dedicated public servants. Our docket is extremely interesting. It's large. I believe it's the second largest docket in the country after the ninth. We have all sorts of interesting cases of all sorts of types, and it's never a dull moment. So that's a long answer to your question. I've forgotten what the question was actually.
But you answered it perfectly. So thank you for explaining, how you ended up on the Fifth Circuit. It sounds like, maybe a little bit more than dumb luck, but perhaps some providence in there. I'm glad that you...
I wouldn't disagree with you.
So this is a little bit of an aside, but I've always wanted to ask an attorney who's practiced in Louisiana, what is it like? And now that you're on the Fifth Circuit, you need to take appeals from both Texas and Mississippi as well. So obviously the civil law in Louisiana tends to differ a lot. I think there are a lot of 1Ls that would have liked to take property as an elective and probably would have elected not to. So how does that affect your your work, having to jump between the different types?
That's a good question, because it is true. We are, the Federal Circuit, we're a common law court. We're not, there's nothing civilian about the Fifth Circuit. And yet when cases come from Louisiana in diversity, and I don't know who your listeners are going to be, but that's when the parties are from different states. And a Louisiana case comes up. We're applying Louisiana law, and there are some differences in Louisiana law. It can be exaggerated, though, the difference. If you're dealing with an issue of property, then the terminology looks quite different in a property case. There's some similar concepts to common law property, but the terminology looks different. So I've decided Louisiana law cases on my court, and I like doing it because that's what I was trained in. But lawyers in our modern system have to be adept at cycling between different systems. And so, for example, I took the Louisiana bar when I graduated from LSU, but then within the next 6 months, I took the Texas bar because I was going to be practicing in both Texas and Louisiana. So I took both of them. So it's not a stretch. And frankly, judges who are not from Louisiana can decide cases based on Louisiana law. They can do that. Sometimes they may ask a Louisiana trained lawyer, "Hey, does this look right?" Or, am I missing anything? And they're smart people; they can do that. But it is an interesting. We have a very interesting jurisdiction for many reasons. We span so much of the southeastern United States. You got cases coming from El Paso. You got cases coming from Jackson, Mississippi, and everywhere in between. We've obviously got a huge border with Mexico, and you may have seen that there's always news coming out of that. Yes, and not only is there news, but there are cases coming out. They're immigration cases, they're criminal cases. And because whatever administration happens to be in the White House or in Congress, you're going to have disagreements about the extent of federal power and the extent of, as we'll talk about, administrative law. And these often get litigated. And our court has been the epicenter of some pretty important litigation over the last few years. And, that's exciting.
Absolutely. And I think that's probably one of the neatest parts about being a judge is seeing what comes in that week and what you're dealing with, on the daily. I guess to the topic of today's symposium and to the topic of today's podcast, the administrative state. And as you mentioned, there are going to be a variety of different listeners. Would you describe what your take on the administrative state is generally? What is this buzzword that we throw around?
Well, again, that's another good question, because the phrase gets thrown around a lot in the popular media and popular consciousness. But from a lawyer's perspective, from a judge's perspective, what you're talking about is the law of administrative agencies. Administrative agencies have been around for a long time. They are creations of the federal government. I mean, they're not, I mean, your listeners, if they're even remotely well educated, they know about the three branches of government. They know about the Article 1 of the Constitution that creates the Congress. They know about Article 2 that creates the executive branch. They know about Article 3 that creates the judiciary. Administrative state is outside that framework, and therein lies some of the difficulties and some of the controversies, because modern governance, although it's always been complex, governance is always complex, especially in a large country like this. And the government has always, to some extent, used agencies, creations of the government, to help them govern, whether it's the executive branch using an agency to, a modern example would be the Equal Protection Agency, to administer the vast complex of environmental laws. The Federal Communications Commission, these sorts of things go way back. They're a means to govern, to help govern, to help execute the laws, to help govern us, to make it as broad as possible. And so your listeners may think, great. I mean, we need help governing. It's a big country. We need help. The problem, though, is that government, one of the fundamental principles of our government in the United States is that it is accountable to the people. And there are different ways of the government being accountable to the people. I guess the easiest to understand is the House of Representatives. House of Representatives is traditionally, by design in the Constitution, supposed to be the popular branch of government. We have representatives. We vote for them. They go to Washington, D.C. They represent us. Poorly, well, it's up, it depends. They represent us. There are folks they represent us. The Senate, in a sense, represents us as well. Originally, the Senate represented the state as bodies, and they were selected by the legislatures. Now senators are popularly elected. So they represent the people in that way. They may have sort of a different relationship to their constituents, but they're representative. The president is representative in a different way as the head of the executive branch. The judiciary, the judiciary does not represent people, right? The judiciary is its own thing. It's appointed. So it's not representative in any traditional sense like that. But it's accountable because the president nominates the judges, and they have to be approved by the Senate. So there's accountable in that way. Administrative agencies, how are they accountable? Well, I mean, we could talk about that for a long time, but I think it's pretty easy to see that they are in a sense, they're appointed, they're staffed by the legislative branch or the executive branch, and we don't vote for them. The people don't vote for the administrators of the Equal Protection Agency. And yet, they wield a great deal of power, a great deal of money, and the decisions that they make are extremely consequential to the lives of the American people. And so that's the controversy about the administrative state is it accountable to the people? And if it's not, what can one do about it? And that's a big topic. And I don't pretend to have like any grand theory about it. But I can tell you that many of our important cases that we hear and that the Supreme Court hears and that all federal courts hear involve principles of administrative law. And this may appear obscure and somewhat difficult for the average citizen to grasp who's not trained in this. And yet you see in the news the EPA or the FCC or the Federal Trade Commission or the CFPB is a very modern, the Consumer Financial Protection Bureau. These are these are agencies that are doing very, very consequential things that impact our environment, that impact our economy, that impact the internet, et cetera, et cetera, et cetera. All sorts of things. And many of the questions that courts are deciding these days, I guess, let me give you an example of something that your listeners would immediately know about. You may recall that during the pandemic, there was an eviction moratorium issued by the Centers for Disease Control. And the question was, so I guess it was easy to understand the rationale for that. We don't want people being evicted. The times are hard. People can't pay their rent. We don't want people being evicted during this time of grave crisis. So we understand that. But the question then became, where did the CDC get the authority to do that? Because even if you thought it was a good idea, it's a dramatic idea. It's a big idea. And that eventually made its way to the Supreme Court, and the Supreme Court said they don't have the authority to do that. And the reason they didn't have the authority to do that was because Congress hadn't given them that authority. And that's an administrative law question. It's extremely consequential. It's an ad law, as people say. It's an ad law question. And so you're looking at principles about, where does the agency get its power? Did Congress give this power? Is the agency interpreting some grant of authority? And is it doing so within the parameters that Congress set out? Or is it sort of doing something, is it sort of grasping power on its own, maybe for a very good reason? No one thinks, I'm a public servant. I think people in public service and in government are well-intentioned. But another fundamental aspect of our structure of government is that we're not ruled by people's good intentions. We set up a structure, our founders set up a structure of government where power checks power, ambition checks ambition. It's called the separation of powers. And our framers, the framers of our Constitution, the people who ratified the Constitution, thought that was very, very important to preserving freedom. It's a different conception of freedom than many of us have today. Many of us have a conception of freedom today that, well, I have a right, and so somebody needs to recognize my right. Okay, there's something to that. That's important. But there's a sort of a deeper understanding of freedom that says, I am governed by someone, and that system, that body needs to be accountable to someone. It needs to be accountable to me and needs to be accountable to other people who I voted for, say the president or the judiciary that's indirectly accountable to me. And in the clashing of all that, we can get freedom. So anyway, that's another long answer, but you're just letting me talk.
I think that's
talking.
perfect. So it sounds like you've identified two different principles then. You have efficiency, and there seems to be some tension between the two. You have efficiency on one side where the executive needs the ability to enforce the laws that are passed, but then on the other side, accountability. So how do we, confronting the ballooning administrative state, how do we toe that line? What's the process for finding equilibrium there? Well,
again, another fundamental question. No easy answer to that. Let's take the easy example. Congress passes a law, and you know how your representative voted, and you don't like it. So you call up the office and say, "Why'd you do that?" You write a letter, says you shouldn't have done that. Mm-hmm. When he or she comes up for re-election, you vote for somebody else, right? That's called accountability.
We like that.
Yeah, that's accountability. I know who did it. I didn't like it. I'm going to vote for somebody else. Mm-hmm. President is similar to that. The president's obviously not making the laws, but the president has influence over the laws, and the president has policies, and the president has priorities, and the president is very visible and you know what the president's doing, and you can like it and say, great, 4 more years for you, or you can hate it and say, I want somebody else. That's accountability. But when there is a proposed rule from some administrative agency, again, it may be extremely important, it may be very, very wise, it may be necessary. Let's say it's an environmental rule. Well, I didn't vote for anybody in the administrative agent in the EPA. So there's a rule that comes out. Okay, well, the law, there's a law. It's called the Administrative Procedure Act. So there's a law governing what the agency does. And say, for example, the agency is required to publish the rule for notice and comment, so people can say, "Oh yeah, this is great," or "Don't do that." That's a very important process. The agency looks at it. The agency maybe amends the rule and finalizes the rule. Okay, so then there can be litigation challenging the rule. So that's where the courts come in. So that's another way of accountability. But notice that's quite indirect. I'm not, nobody from the EPA is running for office. Nobody's saying, this is my platform on mercury, right? This is my platform on climate change. And so one important issue, or one important principle that has come up in the last years, it's called the major questions doctrine. It's existed in one form or the other in various Supreme Court decisions, but it hadn't been named. And it's pretty easy to understand. It's not so easy to apply, but it's pretty easy to understand. And it is if there's a really big question that has a lot of impact on our politics, on our economy, or on our environment, whatever, big question, and an agency is doing something with respect to that. And I don't want to get into any specifics, although we can certainly talk about some major environmental initiative that has a major impact on our energy.
Sure.
And the agency's doing something. The court is now likely to look at that and say, okay, that's a very important question. Where's your authority to address that question? Show me where Congress said to you, I need you to take care of this. Show me where that is. And in recent cases, the eviction moratorium is a good example. The vaccine mandate case where OSHA was saying workplace vaccination requirements. If the agency can't point to a grant of authority from Congress to do something big like that, the Supreme Court has shown itself increasingly willing to say you've exceeded your authority. Our court has decided cases like that. The Supreme Court has decided cases. It's an important and evolving area of administrative law. And it has the benefit of, the average person can understand that. The average person can say, well, so agency X did this massive thing that's really, really consequential. Where did it get the authority to do that?
That makes sense. Where did the major questions doctrine develop? Where did that stem from?
That is a good question. and you can read the decisions of the Supreme Court in recent years grappling with where did it come from? What is it? What is it? Is it a question of statutory construction? Is it saying we really need some warrant in the statute that clearly shows the agency can do this, or is it something else? That's why I say it's evolving. These doctrines develop in Supreme Court cases. Sometimes they develop in lower courts, and the Supreme Court adopts them or modifies them. And over time, the Supreme Court gets a better grasp of sort of what exactly are we dealing with here. And I think the major questions doctrine is one of them. It may be just a very commonsensical idea that if I'm going to find that an agency was authorized to do this very, very big thing, and what does it mean, very big? I'm using simple terms. I need to be able to find a warrant in the statute for it. And the reason is, I think, one might say, is because of the nature of an administrative agency. An administrative agency is a creature of law. right? It has to be authorized by law. It doesn't just exist out of some sort of, because it's convenient to have it, although it may well be convenient to have it. It's a creature of law. And because the administrative agency is not directly accountable to the people, in order to preserve some accountability, we have to find a legal mandate for it.
That makes sense to me. Could you speak to, as we start to move towards the close here, I think that your position as a judge is unique among the people that we're interviewing this afternoon. And if you wouldn't mind sharing an experience of a case that's come before you that revolves around some of these difficult issues related to the administrative state and having to grapple with those as a decision maker.
Sure. I'll give you an example. Fish. So a case came before my court, and an agency wanted to have a aquaculture regime in the Gulf of Mexico. So the Gulf of Mexico is very important to my circuit, to the economy, to the environment. And aquaculture is fish farming. And in your mind, you may think, oh, that's just this little fish farm experiment over here. This project, which was proposed by an agency, was a very big project, very consequential to the environment, very consequential to the economy. And yet the agency said, no, we want to do this for various reasons. And let's stipulate that there were very good reasons. So it was challenged in federal district court. And interestingly enough, challenged by both environmentalists and by commercial fishermen, saying, no, bad. We don't like this for various reasons. And so fine, a federal court might say, well, you don't like it, but sorry, there are all sorts of things happen that you don't like. But they said, no. The agency did not have the authority to create this large regime. Look at the law that they claimed to have authority under, which was a law about protection of fisheries, basically. And the agency said, no, we did have authority. Look at this part of the law here. It's right there. Okay, so a district court looked at it and said, no, you don't have the authority to do that. If you want the authority to do that, Congress needs to pass a law. It comes up to us. So I was fortunate enough to write the decision in that case, and we affirmed the district court, meaning we agreed with the district court. And the district court was very good, wrote a very well-reasoned opinion that's very helpful to us. When we're a court of review, right? It's very helpful when a district court really writes a good opinion. And I wrote the opinion, and it is rather complex. I had to get down into the nooks and crannies of this law to really tell. Because look, frankly, I don't have a dog in the fight of whether we have fisheries, of aquaculture in the Gulf of Mexico. I have no earthly idea whether that's a good idea or not. I really don't even know if it's going to be harmful or not. I don't know, right? That's not my job. I'm not a fisheries person by trade. I'm not a marine biologist. I'm not a commercial fisherman. What I do is I look at the law and I say, okay, given the rules of interpreting statutes, is it fair to say that Congress gave the agency the authority to do this? And we said, and it was actually a split decision. I was about to congratulate myself on being unanimous, but it wasn't. It was a 2-1. And my colleague in dissent is a very brilliant judge who had very good reasons to dissent. I just disagreed. That's another thing I love about being on the court. It's not personal. My colleague who dissented in that case, I've agreed with him in many cases. But he took a different view. I wrote my opinion. He wrote his opinion. And we did it. I don't remember if they sought Supreme Court review. But it was a very complicated decision, but at the same time, it was simple. Aquaculture. Some people want that. Great. But if the agency wants to do that, they need authority from Congress to do that. And we looked at the law and we didn't find the appropriate authority to do it. That's an ad law case. But it's also very important to the economy, to the Gulf of Mexico, to the environment. And it was kind of interesting. I thought it was interesting. So not all ad law cases can be kind of boring sometimes. Or they can be kind of interesting. And I thought that was an interesting one. To someone thinking, you just blocked that aquaculture program and you shouldn't have done that, Judge. I would say, I'm just applying the law, but I would also say, if the people want that, there's a way to do it. Pass a law.
I think that goes back to the accountability,
That's
right? So for people that, and I think that for the average American, that administrative state is something that we're not aware of on a regular basis, something that even though it affects so many and permeates our society, affects so many different areas of our lives. If you were going to speak to, my parents or whoever else might listen in on this podcast and they want to learn more about the administrative state, where should the average American start?
That's a tough question. I'm not really I hadn't thought about that ahead of time. I mean, you certainly read about it in the news, but in terms of educating yourself about it, I'd have to give some more thought to that. I mean, it is a complicated subject. And the question would be, what I would want to look for are books, not for lawyers. The average person shouldn't read books for lawyers.
No, they're very boring.
Yeah, the average person should read a book. I'm sure there are books out there that treat the administrative state in a way that the normal, average, educated person can understand. You'll see a lot of books critical of the administrative state, to be sure. But in terms of educate, that's a good question. I don't know, but I would look for books that deal with issues like the Federal Reserve, the Environmental Protection Agency. I come back to again the Department of Education, and look for books exploring those areas. And inevitably, they will talk about the administrative state. But it's interesting, the average citizen can easily educate himself or herself about Congress. But about the FCC, I'm not really sure. It might take a little work. But maybe that's the point. They're not as visible. And so the average citizen really, no matter what you think about it, whether you think they're great or you think they're bad, whether you think they need to be expanded or contracted, the average citizen really should know more about this subject because they're so consequential. And again, we don't vote for them. We vote for people who affect them, but we don't vote for them. So the average citizen should know more.
It's tricky, having all that insulation in such large agencies and not being able to find that information. So
well, and to be fair, because I'm trying to be fair, the insulation is part of it's baked into the system because the idea is, well, they need to be insulated from politics because they need to be objective. Fair enough. I agree with that to some extent. They do need to be objective. They need to be driven by expertise. But the question is, how do we control them?
Absolutely. And I think that hopefully will be answered by some more of the symposium that we have today. We thank you so much for joining us, giving us some background and some insight into your experience as a judge on the Fifth Circuit. Is there anything else about the administrative state that needs to be said before we end?
I'm sure it does, but I'm probably not the one to say it. But I'm grateful to be on your podcast.
Well, thank you for being here. We are really appreciative, and we look forward to the rest of the symposium.
Thank you.
Thank you, Judge Duncan.